Diane, welcome back to Criminal Justice 307 here at Sigma College, our undergraduate real property course. Karen and Mary Matchup. Today we are talking about the Statute of Frauds. And if you are to take nothing else away from this talk, or if you're to quit this talk right after that, the first thing I want you to know is that contracts that are covered by the Statute of Frauds, which typically include real estate contracts and contracts for land, are required to be in writing in order to be enforced. Got that? All right, so contracts that fall within the Statute of Frauds, such as real estate and land generally, are required to be in writing under the Statute of Frauds. All right, so that's the general piece, but let's get more into what that means. So first of all, the Statute of Frauds, let's go back in time a little bit to where a lot of common law comes from. Where does a lot of common law come from? Do you remember? England, right? A lot of it comes over from England into early American law and then is codified and created as statutory law sometimes, but oftentimes has its basis in this common law. The Statute of Frauds is actually a statutory law from the get-go, being as it's called the Statute of Frauds. Statute just means law, right? And statutory just means laws that are kind of published or written as laws, as opposed to just sort of common understandings. And so in England in around 1677, there were two lords, Nottingham and North, who are considered to have authored the original Statute of Frauds in an article by Evander Willis called The Statute of Frauds, a Legal Anachronism. He notes that those two take much of the responsibility for different sections of the original draft. He also says that the original purpose for the enactment of the Statute of Frauds was to prevent frauds caused by perjury, or in other words, to make sure that legal effect should not be given to transactions that were never actually entered into, and that parties shouldn't be held on promises never made. The statute undertook to accomplish this purpose by the requirement either of written or other adequate evidence of such promises in certain cases where at that time, because of perjury, it was thought that there might be a danger that people might be held on promises they'd never made, all right? And so the statute basically it introduced some other changes into the law as well in terms of land, succession to chattels, procedure, but the main purpose of the Statute of Frauds was to make sure that people weren't fraudulently claiming that others had entered into certain contracts that they hadn't, or hadn't entered into the exact contracts they were claimed to have entered into. All right. So generally, the Statute of Frauds includes a couple main components. It would include a piece related to the sale of goods, contract for the sale of goods, which would be generally personal property, totaling $500 or more. That would require a writing and otherwise fall within the Statute of Frauds. Contracts by the executive or will, for example, to pay a debt of the estate with that money, or with their own money, I should say, might fall within the Statute of Frauds. If you're acting as a guarantor or what they call a surety for another person's debt, that might fall within the Statute of Frauds. If you can't perform, and this is kind of important, a contract within a year, it would fall within the Statute of Frauds. And if you've taken contract law with me, you know all of this and you've heard all this before. And considerably, so I'll note also actually marriage and prenups fall within the Statute of Frauds generally too. But the big point for this class is that any transfers of interest in real estate or land fall within the Statute of Frauds. That means that there might be, or there must be, a writing. So this is again, the Statute of Frauds is a type of contract or covers types of contracts which have to be in writing to protect against and prevent fraud and other injury. And they also have to be not only in writing, but generally signed as well by the parties involved. Most commonly, these actually are land contracts, whether that involves the sale or the transfer of land, as well as other contracts which are either over $500 or can't be performed within a year. In order to satisfy the statute of frauds, the writing or the written instrument, we might say, or it could be a memorandum, it has to contain usually 5 elements. And these elements are the signature of the parties, the identities of the parties. And so we talk about that contract law. You have to not only put their names in there, but kind of, if you have a name that's like, John Doe, and there's 5,000 other John Does, John Doe of 555, University Ave, University City, University State, just to make sure you're properly designating or identifying that individual. You also have to identify the subject matter of the agreement. And if it's something which is of substantial value and it's a specific item, for example, you have to, if there is some way to individually identify it, that is good to include too. So sometimes you'll see pictures of rings, for example. Sometimes you'll see the serial numbers on different electronic devices. The VIN numbers of cars are generally included within contracts in order to identify the subject matter and therefore correctly fall within the statute of frauds. The terms and conditions of the agreement are required to be in writing, do have to be within the statute of, do fall within the statute of frauds as well. And then the consideration, and this is another contract law term, but consideration just means basically like the payment, what is being exchanged for the item that's being sold. And that needs to be within there as well. If you take contract law, you'll know that generally, not only does the consideration have to be in there, but when the consideration is due is generally good, things like that. But that's in the weeds for what we're talking about today, which is simply that if you are going to do land transfer, which we're going to be talking a lot about, it has to be in writing. And so those are general common law principles, and states have incorporated those, and the federal government did as well. The US federal government did as well within the UCC, the Uniform Commercial Code, which we'll touch on. And then tribes have incorporated pieces of those as well. And that's how this common law idea takes practical effect and can be utilized by you or someone else. All right, so I'll start out by looking at Standing Rock. If you want to, if you're not aware of this, the National Indian Law Library, it's not an up-to-date list, and unlike with other tribes, you can't necessarily click on them and see their contents right away. But the National Indian Law Library, which is part of the Native American Rights Fund website, I believe, yes it is, they have many tribal codes, and they do have Standing Rock's tribal code table of contents on here. Again, whereas some other tribal codes they have are linked the section by section, Standing Rock is not, and in fact, some of these pieces are not in there. But if you're looking for something that you expect to be within the Standing Rock code, this is a good place to come and search. On the tribal website, many of the publications of the code are not searchable. You can't, for example, do Command F or Control F find in order to find something within the document. This actually is, so you can actually search right in it and see, different parts of the code which relate to whatever you're looking at. And then you can use this table of contents to go and say, okay, so I need to be looking at, for example, at Title 14, for probate information. I need to be looking at Title 15, Chapter 2, Section 6 or Section 206 for notification or publication related to notice of election. All right, and so this is a good place to start for Standing Rock if you know something should be within the code somewhere and you're just trying to find it. I'll note that the Statute of Frauds has pieces which are incorporated both for Standing Rock into the tax code as well as into the commercial code. And so you don't, the statute of frauds, sometimes it's not incorporated wholly, it's incorporated, or it's not incorporated as one giant piece of the statute. Sometimes the individual pieces of it are split up and put into different parts of different codes. But oftentimes tribes do incorporate similar ideas. Okay, that's actually, this is a slide related to personal property versus real property. Just to note that real property is almost always subject to the statute of frauds. Personal property isn't unless it meets the qualifications. For example, being goods over $500 or more, and then some states have it over more money than that, or that figure might change, or if they can't be performed within a year. And so you say, like, in 3 years, I'm going to sell you my pocket watch. That would be subject to the statute of frauds. And you can think, well, why would you want that to be in writing? And if you're making a contract for 3 years from now, in writing certainly seems like a good way to remember it, right? So if nothing else, it does keep you honest, and that's the intent, is to avoid there being any kind of fraud. All right, and when we talk about in writing, I should note, because I see some sort of napkin looking things here, or a handkerchief, probably it is. In writing basically just refers to it being written down anywhere that you have a copy of. So if you are sitting in a restaurant and you have a napkin in front of you and you write down this contract on a napkin and you both sign it and you both meet all of the qualifications for it to be a contract under the statute of frauds, then that's a contract. It doesn't matter that it's on a napkin. It doesn't need to be written by an attorney. It can be written by another individual, by you. But it does have to meet or satisfy the statute of frauds in order to be effective. So, okay, so I'll note, this is me pulling from the North Dakota Century Code. So the North Dakota Century Code, let's go there actually. If you're trying to find the statute of frauds information for North Dakota, you might go to the North Dakota Legislative Branch website, which has on it the North Dakota Century Code, which are the laws of the state. This doesn't include all the regulations of the state, which may be found under individual departments, but it includes the laws of the state. Within the Century Code, if you are to search just for contracts, is where it often is, contracts and obligations is at chapter 9 here. We look within chapter 9, scroll down, I see chapter 9-06, section 06, that is formation of a contract. I bet there will be a statute of frauds provision within here, and then sure enough, here it is. So contracts, invalid unless in writing. And you see here that the state of North Dakota has incorporated a statute of frauds. And so it has 5 different pieces within their statute as well. They're a little bit different. It says an agreement that by its terms is not to be performed within a year. So that's a familiar one to us, right? A special promise to answer for the debt default or miscarriage of another, except in certain cases. You would have to actually go to this section to see what that means. An agreement for the leasing for a longer period than a year, or for the sale of real property, or an interest therein. All right, so that's the one which is relevant, especially relevant to us in real property this semester. An agreement for the leasing for a longer period than 1 year, or for the sale of real property, or of an interest therein. So that covers most of the kinds of conveyances that we are going to be talking about in this class. Such agreement, if made by an agent of the party sought to be charged, is invalid unless the authority of the agent is in writing, subscribed by the party sought to be charged. So basically, if you have your real estate agent, and they don't even need to be in, it uses the word agent, but it can be somebody who's functioning in an agent capacity, whether or not they're known as an agent. So if you have somebody who's going to buy a car for you, for example, unless it's in writing by you that they can do that, or buy a piece of land for you, maybe it's a better example. Yeah, we'll use buy a piece of land for you. Unless you have it in writing that they can do that, there might also be an issue there. An agreement, because, and the reason for that is simple. It's because agents, there's a whole set of laws related to agents, and agents is just it's even people we don't consider agents. It's not like secret agents, it's not like BIA agents. Agents are individuals who work on behalf of other individuals. And so the goals that they're trying to accomplish aren't their own, but they are those of that individual who they're working on the behalf of. And the agent is subject to certain basically protections and then also restrictions to make sure that, for example, if you tell Johnny that, oh, Johnny, would you go buy this house for me? And Johnny gets there and he's like, darn, this is a really cheap house. I'm just going to buy this house for myself. You know, maybe he can't actually do that because he was supposed to be buying it for you if he's your, agent in that way. And so there's a whole set of actual different laws and regulations related to the status of agents and that. But basically what they're saying within this section 6 under chapter 9 of the North Dakota Century Code at subsection 4 clause 3 is that if you're doing any sort of real property transaction, or if you're having someone do it on your behalf, it needs to be in writing and signed. And it also, if you do have someone do it on behalf, their ability to do it on your behalf has to also be in writing and signed. All right, 2 more: an agreement or promise for the lending of money or the extension of credit in an aggregate amount of $25,000 or greater, an agreement or promise to alter the terms of repayment or forgiveness of a debt that is in an aggregate amount of $25,000 or greater. All right, so you can see there's some more parts of this formation of a contract. I also put in an example of the consent requirements. And so just to note that, even though, yes, this is where the statute of frauds is codified within the North Dakota Century Code, North Dakota state laws, there are other parts of the state laws which do have an impact. Like, what does it mean to consent? When is there duress, menace, fraud, undue influence, or mistake, etc. So there are some other sections which play a role in this as well. All right, looking then to South Dakota, if you go to the South Dakota legislature site, and why would it be under the South Dakota legislature site? Oh my goodness, I'm sorry. Site. Why would it be under there? Well, because they're the ones who are writing the laws, right? They're having bills come before them. They are enacting them into law. Sometimes they do it all in one kind of fell swoop for pieces of for big codes and other things like that. Like they might enact multiple parts, or maybe they might have enacted all of Title 53 in one fell swoop. Standing Rock frequently does that too. Or they might have gone through and made changes over the years or amendments or added different parts. All right, so we're in and actually I'll just show you even how to get there. I think I can do that. We're in the sdlegislature.gov and we go to codified laws. And then within codified laws, we are actually going to, if we can find it right away, which I'm not finding it. Oh, well, I see the Uniform Commercial Code right there, but let's just see what happens if we do search statute of frauds. All right, I forget which one this is actually at. So let me open this up for a second. We can just kind of look and see. Okay, we're actually not looking at. So you can see that, however, there are 127 results within the codified laws to those terms. However, they're not used specifically like that. If we put quotation marks around them, I wonder if it'll give us a sort of Boolean type connector here. Okay. Let's look within this law. All right, so these are leases, general provisions, and you see that for leases, there's actually a specific statute within the lease laws related to the statute of frauds, which is that a lease contract is not enforceable unless X, Y, and Z. And then it goes on to how a writing is needed, if there is a writing signed by the party, etc., how that kind of goes through. And so that's specifically for lease contracts. And then we can actually get into, I might go back. We can actually get into maybe the general inclusion of the statute of frauds here. So under contracts, all right, so chapter 53-8, oral and written contracts, and we see contracts required to be in writing under the statute of frauds. All right, now remember there were 127 or 126 other references to the statute of frauds. And so there may be other occasions where in contracts or leases or other things have additional provisions related to the statute of frauds that you should probably be aware of too. But looking generally at contracts required to be in writing the statute of frauds for the state of South Dakota, they've got this split up into 4, which is just a different way of splitting it up. And it says that the following contracts are not enforceable by action unless the contract, and what does enforceable by action mean? So enforceable by action means that you can't bring a suit against somebody. You can't go file a complaint in civil court and have it enforced by the court. That would be an example. Or if you have some sort of order, that is otherwise unenforceable. So the following contracts are not enforceable by action unless the contract or some memorandum thereof is in writing and subscribed by the party to be charged or his agent as authorized in writing. And so why does it only say by the party to be charged? This is because you may be, for example, you may be the one who is bringing the complaint. And so if you're the one who's bringing the complaint, then what you need to show is that the party that you're complaining against actually signed on and agreed to the things that you're alleging in order to enforce it against them. So it's not necessarily one party or the other. It's the person who the complaint is being brought against. So just a note here under these 4, an example as an agreement that by its terms is not to be performed within a year. So again, that's similar within a year one that we saw as the first one for North Dakota as well. An agreement made upon the consideration of marriage other than a mutual promise to marry. And so that's sort of old language, but still included within the South Dakota statute. We didn't see that exact language within the North Dakota statute at all. An agreement for the sale of real estate or an interest therein or lease of the same or for a period of longer than 1 year. And so that's even a little bit different than North Dakota, right? However, this does not abridge the power of any court to compel specific performance of any agreement for the sale of real estate in case of part performance thereof. And part performance might be less than a year. Part performance may be, for example, somebody who has started basically buying the real estate and has put down $250 of the $500 or whatever. It probably would be more, but so a little bit of different language. And so sorry to use that word again. One of the things that, if you were wondering, what attorneys do, and if you're interested in going into law school, is, reading these types of laws and knowing how to research them, like you just did here on the South Dakota legislature site or the ND Century Code site, knowing how to research them, find them, knowing how to read them, and sort of knowing how to interpret them or how the courts are going to interpret them. So it's understanding a little bit more about that, and then being able to do an analysis on a specific set of facts to see how that would result. And so there's a lot involved in that, and that's what a lot of what being a lawyer is. So it's not as much of the arguing in the courtroom, although you can be a litigator who does that as well, and there are people who specialize in that. But a lot of being a lawyer is doing this sort of doc review refers to something else, but doing this sort of review of legislation and the laws, and then doing an analysis. So in the format that we talk about with legal writing, if you had Wayne Shelley before me, you might remember him talking about this, or you might have heard this elsewhere, and you might hear this when you go onto law school. If you talk about IRAC or CRAC, you're doing like the issue, the rule, the analysis, and the conclusion, or the conclusion, rule, analysis, conclusion, however you like to consider it. What you're looking at there is you've got an issue. So somebody comes to you with a problem, and somebody says, okay, you know, Joe Blow stole, or Joe Blow is saying that he bought this property from me, but I never signed anything that gave him the property. Okay. And then Joe Blow says, well, I gave her $250,000. So I partially performed the contract. Okay. And so you then go to an attorney and you say, hey, you know, I'm in South Dakota here. What do I do? You know, and this is off res because it's not within tribal jurisdiction, or, you know, maybe it's fee land. But I would say off res. And you go to the attorney and they say, what do I do? And so the attorney looks this up, just like we've looked it up now. And they say, okay, so here's what the statute says. You know, you're right. Generally, if you didn't sign, it wouldn't matter. But there is actually a piece of the statute which says something about part performance, which sometimes is called partial performance. And it doesn't abridge the power of any court to compel specific performance. Specific performance may actually be turning over that property and signing over the title of something. So I don't know that a court would actually read that way, because the statute of frauds is so embedded within the American jurisprudential system. But that's that process. And so the issue would be like whether or not, if you were writing this out for the court, whether or not your lack of signature invalidates the supposed land contract between you and Joe Blow. Maybe that's how Joe Blow would phrase it, or he'd phrase it in a way that was beneficial to him, or favorable to him, I should say. Maybe on the other hand, you might say, you know, whether or not Joe Blow has the right to take my property without, you know, my permission, and there's no evidence to show permission. So that would be the issue. And then you'd look at the rule. The rule in South Dakota is, and you'd cite to this at 53-8-2 that X, Y, and Z, and you'd argue in your analysis, and you'd look specifically in your analysis, you might look to what the court had done before, what we call precedent. You might look to the specific language. You might go back through the legislative history to see what, when the South Dakota state legislatures were passing this, what they were thinking about and what they intended by these words, or what these words generally mean. And that might all be part of your analysis. And then you may come to a certain conclusion. Therefore, Joe Blow is not entitled to this property. And you would submit that in your complaint or in your response to the court. And then the court would be reviewing those things, right? And so that's a lot of the function of an attorney. And so you right now, you're getting some of those skills. This is no substitute for law school. Nothing I say here is legal advice, as I disclaimed at the beginning in writing, actually. But this is a lot of what those individuals will do. Okay, so we see an example of a complaint like that here, which is the Muskogee Creek Nation versus the Porch Band of Creek Indians. And you see that this is actually the complaint on behalf of the tribal defendants. The defendants in this case would be the person after the V, so they'd be the Porch Band of Creek Indians. And so these are the attorneys who are working for them out of DC, and then a firm that looks like it's local out of Alabama, which is where Porch Band, which is in the area of where the Porch Band of Creek Indians tribal lands are. And you see that they're arguing that the statute of frauds bars the plaintiff's promissory estoppel claim, and they're saying that under Alabama's statute of frauds, an agreement that cannot be performed within 1 year is void unless made in writing. So there must have been some agreement, and you can read more about the case if you'd like. It's within Turtle Talk. You can get to it. I talked about Turtle Talk in some other classes. I don't know if I've talked about it in this one yet, but you can get in there and read more if you want to. And so they're saying under Alabama statute of frauds, an agreement that cannot be performed within 1 year is void unless made in writing, and then they cite to it. So this is the similar type thing that we just went through with North and South Dakota, and then looking at for Standing Rock as well. And that's how that that happens. I'll note that the statute of frauds got brought in the US, basically got added within the Uniform Commercial Code. And so that was an act first published in 1952. If we see here, does it say 52? Well, this says 63, but I think that the Uniform Commercial Code was, I'm almost certain it was first published in 1952. So this is the 1963. Okay, okay, so this is why. This is only for the District of Columbia. So this is an example of it being, this isn't the original code. This is it being applied for the area of the District of Columbia. And they're actually bringing in a lot of that Uniform Commercial Code. I don't know if I can search it here and see if Statute of Frauds is in here. Okay, so we see here Statute of Frauds for kinds of personal property not otherwise covered. And then I was maybe look to see if, right. So they have a thing about sending there. They're referring to the mailbox rule probably. All right, so you can find basically within this statute of fraud somewhere I'm so sorry, within this Uniform Commercial Code as it was being applied for the District of Columbia. The statute of frauds that's been put in there. And so there are some exceptions to the writing. Sometimes there's a thing called the merchant confirmation rule. If you have a business owner who sends something to someone else that's sufficient enough to satisfy the statute of frauds, and they have reasons to know about it and they don't reject it, then they can basically confirm it, even if that confirmation isn't signed. So if Tracy at the bookstore, for example, frequently does business with an individual and she does, say thousands of dollars worth at a time, and maybe she sends them, something related to something she's buying or selling or whatever, and they don't necessarily respond, but they, this is part of their regular course of business, or there are a lot of kind of exceptions along those lines. There's also exceptions related to things that are specifically manufactured. And so if you, are like, hey, can you bead my regalia, or can you make me a set of beaded regalia? And you have a person who begins to actually put them together, then that would be a little bit of what South Dakota had referred to as part performance, or sometimes referred to as partial performance. And then you've also got, for example, the admission of a contract. Sometimes within the statute of frauds and the way that it was incorporated with the Uniform Commercial Code means that, I don't know if it was admitted. Okay, so I don't know if it was within. Okay, yes. So if they admit it in court that a contract of sales was made, so this is like the admission of the existence of a contract by the defendant under oath, that contract was made, and that would actually satisfy it as well. So there are a couple exceptions, maybe more than a couple if you get really deeply into it. But for the purposes of our class, the main thing to know, if you can remember this, as I stated in the beginning, the statute of frauds requires certain contracts to be in writing and signed by the parties bound by that contract. The purpose of the statute of frauds is to prevent fraud and other injury. The most common types of contracts, and this is from the Cornell Law School Legal Information Institute, the most common types of contracts to which the statute applies are contracts that involve the sale or transfer of land, and contracts that cannot be completed within a year. All right, with that, that is your introduction to the statute of frauds.